I don't know if you're a great reader of articles, folks, but if you are, there is an article you need to read. It's been published in, I think, the New Zealand Law Review. And gosh, I don't know, I got clearance. We've published it on the platform's opinion page. It's by Roger Partridge, our next guest from the New Zealand Initiative. And it's an important article about the law in New Zealand and who makes it. And whether it's our parliament, which is formed after a democratic process, or our judges who decide what the law is in New Zealand. Roger has taken apart or investigated cases where judges, New Zealand judges, have quite apparently to the layperson gone against the wishes of the parliament, who recently passed laws to ban gang patches and create laws in which courts could take gang patches and gang insignia off people. But there have been 2, maybe 3 incidents of late where judges and courts, having taken the gang patches off people, have then given them back to them. I've scratched my head at that, but what Roger Partridge has done from the New Zealand Initiative is look in a very legal and detailed way at how the courts did that. And how they did it, I have found, even with my layman's knowledge of the law and our democracy, rather disturbing. So Roger Partridge joins us now. Firstly, Roger, thank you. That was, as I read it, and I'll be honest, reread it, because it's a not super technical, but it's a detailed piece of writing you've done. It seems to me you are pointing towards a most disturbing development for any democracy in broad terms.
Look, I think that's absolutely right, Sean. And it's an example or a good illustration of the problem that I wrote about in a report for the New Zealand Initiative late last year called Who Makes the Law? Reigning in the Supreme Court. And the fundamental problem is that our courts have stepped outside their constitutional lane. Your viewers or listeners will know that there are 3 branches to our government. The Parliament, whose primary job is to make the law, democratically elected, democratically accountable. If the people don't like laws passed by Parliament, they can vote parliamentarians out. So that's the first branch. The second branch is the executive that implements the law. In this case, it's the police. The Gangs Act prohibits displaying gang patches in public, and so the police do their job by applying that law, giving effect to it. And then the court's job is to interpret Parliament's words and apply it in the courtroom. What we're seeing increasingly is the courts reshaping Parliament's laws when they don't like the outcome. And this is a classic case here. And the problem stems from our Supreme Court, which has given the courts below a toolkit to sidestep Parliament's clearly expressed words. And when they do that, there are 2 significant harms. First, we get uncertainty, what lawyers call the rule of law. Laws are supposed to be clear and certain, and they're supposed to be equally applied. But if judges start stepping into Parliament's role and making the law or reshaping Parliament's laws, then the rule of law breaks down. And the other problem is the law loses its democratic legitimacy if it's made by judges who aren't elected and aren't accountable, rather than by Parliament, which is accountable to voters. And so this case, we should talk about this case because it's a fascinating one. This case is a classic example of a lower court using the toolkit given to it by the Supreme Court to sidestep what Parliament clearly wanted to achieve.
All right, let's talk us through that, and talk as if you were talking to a child with no tertiary education and only limited secondary education.
That's how I try to interrogate myself as well. So hopefully it won't be too hard a task for me. But the Gangs Act was passed in 2024. It was one of the current government's first marquee pieces of legislation under its tough on crime policy. Its purpose was to reduce gang intimidation by prohibiting the public display of gang patches. And it provides a simple, you'd have thought, two-step test about what happens when someone's convicted or pleads guilty to a breach of the prohibition. The first step is that the gang insignia involved is, and this is a direct quote from the legislation, is forfeited to the Crown. So that's step one. The second step is the gang insignia is to be destroyed or otherwise disposed of as the court directs. So two steps. So in this case, it's in Taumarunui, a mongrel mob member, Mr. Leaf, pleaded guilty to displaying the gang patch in public. And under the Act, you might have thought that would have triggered this simple two-step process. The insignia would have been forfeited to the Crown.
And destroyed.
And then the court would have told the Crown how to destroy or dispose of the gang patch. But in the District Court, Judge Rowe turned Parliament's clear words upside down, and he treated disposal as a gateway to undo forfeiture and ordered the vest to be returned to the defendant. So completely inverted what Parliament clearly intended.
And how the hell did he justify that, Roger?
So he used two tools which courts have been provided effectively by the Supreme Court. The first is a principle that the courts have invented called the principle of legality, which allows or confer, it's the courts conferring on themselves the power to reinterpret Parliament's words if they infringe what the court thinks are fundamental rights. Now, some of those rights are laid down in the New Zealand Bill of Rights Act. So the courts think they have jurisdiction or the power to reinterpret even clear words from Parliament. And so, and those principles, probably the high watermark of their application was in another piece of a national government's criminal legislation, the three strikes provision, in a case called Fitzgerald and the Crown, where the courts effectively rewrote the three strikes legislation to avoid what they considered would be a disproportionate third strike maximum sentence. So that's the first tool they use, based on the Fitzgerald case, where they've conferred on themselves, they've purported to confer on themselves the right to stretch Parliament's words to avoid an unjust outcome. And the second tool in the toolkit, if you like, is the Supreme Court's decision in the Ellis case, which might be familiar to some of your viewers. This is the case involving Peter Ellis and whether his appeal could continue beyond his death. And the court found that it could, and in doing so, it relied on tikanga and determined that tikanga was potentially relevant.
And tikanga is also in the gang patch thing, because some guy got it given back because he said it was his family crest and therefore part of his tikanga.
Well, it's even worse than that, because he didn't actually argue tikanga, and there was no evidence before the court of what tikanga might require in this case. The judge decided that the gang members' statements that the mongrel mob was like his family and that the gang patch was like a family crest, he said that was akin to tikanga arguments, and then proceeded to treat the tikanga as if it had been proved in court and could be relied on again to sidestep Parliament's clear words.
Roger, look, people who have read the article, I recommend people read it half an hour ago. I'm getting texts from people saying, I'm not a lawyer, but this is bloody serious.